Hello everyone, welcome to Court with Krissy. Time for an update. Remember this one? Yeah, that one got worse. But this one gets much better. The old man and his even older attorney, they made the drive north this time. And the judge has not one, but two apologies to put on the record. We're all human, we all make mistakes. I hope you like it. Court with Krissy is now in session.
Appearances, counsel.
Nick Carnes on behalf of the people.
Good morning, Your Honor. George Sirkin on behalf of the defendant. Your Honor, with your permission, we approach the bench.
You may, but before you do that, why don't you go ahead and have a seat, because I want to address something else. Mr. Securian, I need to apologize to you for my behavior of last week. It was very unprofessional of me, and you did not deserve that. So I sincerely apologize. I truly let my temper get the best of me.
You know, Judge, that's fine. We all make mistakes, Your Honor, and I think it was on the clerical side. It's understandable, Judge. Please.
Well, I do apologize for that. I truly do.
Thank you, sir.
And it's my understanding that we were here for several motions today, but I've been informed that there's a resolution in the matter.
Yes, we have.
Okay, Mr. Carnes?
Your Honor, it's my understanding the defendant will plead guilty to operating while intoxicated first. That'd be count one. The people will dismiss count two, operating with a high BAC.
Mr. Securian, is that
That is correct.
correct? All right. Mr. Fenton, have you heard what the attorneys have said the resolution is in this matter? You can stay seated, both of you.
Yes, I have, sir.
Okay. And is that how you wish to resolve the case?
Yes, it is.
Mr. Securian, before we went any further, was there something you wanted to give me, or was it part of the plea process that we're doing now?
No, I don't think those.
I thought you wanted to approach that. Okay.
That was all. You took care of that. Thank you.
All right. All right. Mr. Fenton, will you please raise your right hand? Excuse me. Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. You may put your hand down. It's my understanding that you'll be entering a guilty plea today to what is essentially count number one, operating while intoxicated. That is a 93-day misdemeanor and or a fine of $100 to $500 and or 360 hours of community service, rehabilitative programs, vehicle immobilization is mandatory with a prior, reimbursement for the costs of prosecution and governmental expenses. In exchange for that plea, the people dismissing count number two, which is operating with a high BAC, which is a 180-day misdemeanor, fines and costs of, or fine of up to $200 to $700, 360 hours of community service, rehabilitative programs, vehicle immobilization with a prior, and again, reimbursements for the costs of prosecution and governmental expenses. That's your understanding of the plea agreement?
Yes, it is, sir.
Do you understand that the prosecution could not move forward on both counts? If you were to go to trial, they would have to choose one over the other before moving forward. Do you understand that?
Yes, I understand.
And knowing that, you still wish to enter the guilty plea today?
Yes, I do.
Were you on probation or parole back on February 23rd of this year?
No,
Were you on bond in any other file?
no.
I have a signed advice of rights form, talked about your rights to an attorney and your rights to a trial. Did you read and sign that form?
Yes, I did.
Did you understand those rights?
Yes, I do.
Do you have any questions for me about those rights?
No, I don't.
Most importantly, do you understand that by entering a guilty plea today, you'll be waiving those rights and you won't have a trial of any kind?
Yes, I understand, Your Honor.
Other than the agreement today, has anybody promised you anything in order to get you to plea?
No, sir.
Has anybody threatened you in order to get you to plead?
No, sir.
And is it your own free choice to plead today?
Yes, it is, Your Honor.
Are counsel aware of any other promises, threats, or inducements in which to get the defendant to plea today, which have not made part of the record?
No, Your Honor.
All right. Then Mr. Fenton, to the charge that on or about February 23rd, 2025 in Herring Township here in Wexford County, how do you plead to operating while intoxicated?
Guilty, sir.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on February 23rd, were you operating a motor vehicle here in Wexford County?
Yes, I was.
And you take exception that that would have been in Herring Township? I realize
Yes,
you're not from the
correct.
area. And had you consumed alcohol prior to operating that motor vehicle?
Yes, I had.
And were you stopped by law enforcement?
Yes, I was.
Were there chemical tests or blood tests done?
Yes, there were.
Mr. Carnes, do we have the results of the blood test?
Yes, Your Honor, we do. Your Honor, the blood results came back at a 0.214. The people would stipulate to that amount.
Do the defense stipulate? for purposes of the plea? All right. Do you counsel believe the defendant has provided a factual basis in which to accept the plea and that the court rules have been complied with?
Yes, Your Honor.
Yes, sir.
As does the court. Mr. Fenton, I find you guilty of operating while intoxicated. Pursuant to the plea agreement, the operating with a high BAC will be dismissed at the time of sentencing. I have received a substance use assessment in this matter. Mr. Carnes, have you received that?
Yes, Your Honor.
This is not the type of assessment that the court is used to. Our treatment provider up here goes into a lot more detail. Mr. Carnes, do you have any concerns with using this assessment?
Your Honor, I did initially, and then I read through, and it seems to have a diagnosis. I'm satisfied with it as it exists, but I certainly respect the ruling of the court on that.
Well, I'll be honest, the court has gone back and forth as to whether or not I wanted to accept it. Most of all, I could not find anything on what a score of 24 on a alcohol use profile means. Additionally, in regards to the legal section of it, it just said that the defendant hadn't, let me make sure I can read exactly what it says, that has his first ever alcohol related driving case pending in this district court, which is probably true, but it didn't go into any prior history. So then I look back at the defendant's history, and it seems that he had allowing an intoxicated person to operate a motor vehicle. However, I think we can probably still use the assessment given the defendant's age, no disrespect, but the fact that he has no prior record other than that allowing an intoxicated person to operate. So I will go ahead and I will accept the assessment.
Thank you.
Are there any corrections or additions that need to be made to the assessment?
Not on behalf of the people.
All right, Mr. Serkin, allocution.
Your Honor, I would like to indicate for the record that my client is 67 years old. He's a retired engineer out of the Ford Motor Company for many years. He's raised 7 children, put all of them through college, Your Honor. Other than this problem, he's never had a problem in his life. And he's learned a lesson, I think, this time around. Since the arraignment in February, he's tested clean for alcohol twice a day for the last 3 months. He's involved in an alcohol treatment program online. He can't drive, so he's doing it online. And he's very, very determined, Your Honor, not to go through this procedure anymore. He tells me that at that particular morning, when he was stopped, Your Honor, he was at the ski lodge, which he goes in the wintertime with his children and grandchildren. And he stayed at the lodge, and they had a party going on. And he got caught up in the party, and he thought that, well, I'll have a room. So he just stayed there and he kept drinking. After the bar closed down, when he went to check into the lodge is closed. They didn't have any room. So he stopped and thought for a while, and he reflected on his episode in Wixom. What happened in Wixom was the same thing. When he left the bar at 1:30, he realized he shouldn't drive. So he didn't drive. So he stayed in his truck, turned the engine on, turned the heater on. It's mid-February to keep warm. The police come by and they charge him. And that before we went to trial, the police officer kept saying, well, as far as I'm concerned, the truck was in drive. But he did testify it wasn't moving. And the engine was on and the heater was on to keep him warm. So he wanted to avoid a trial. And when he came up with the plea agreement of allowing an intoxicated person to drive, that was no points on his record. It did not show anything, so he accepted that. This time around, Your Honor, when he realized that the room was not available, he thought to himself, well, if I start my engine to keep warm and keep the heater on to keep warm, I'm gonna wind up with the same thing. So what he did is he reserved a room at Comfort Inn on his app. And I sent a receipt of it to the prosecutor. He reserved the room, and he thought that he could drive the 10 miles or so to the Comfort Inn. To his credit, he didn't try to drive home. He realized he shouldn't drive at all, but he thought, well, at the very least, I can make 10 miles, and he did not. So, Your Honor, this is the circumstances under which he's appearing before this court. To his credit, he did not have an accident. He was not speeding. The officer observed that he crossed the center line, and the officer had caused a stop. And of course, when he did go through the sobriety test, he failed that. So there's no question, Your Honor, that he was drinking. He acknowledges that. He never denied that to me at all. So all I can say, Your Honor, with all of that said, I would appreciate whatever consideration you could give him, Your Honor. And as far as if Your Honor feels that probation has to be mandated, I would ask if there's any way we could have probation in Novi where he lives, or actually, Your Honor, if Your Honor would be kind enough to even forego the probation, I would appreciate that, but I leave that to the discretion of the court.
Okay. Anything else?
Nothing else, sir. Thank you.
You said he was coming from the ski lodge and he had about 10 miles, so I assume that's Caberfay?
Yes.
Okay.
Yes.
All right. Allocution, Mr. Carnes?
Thank you, Your Honor. I don't know the sequence of events. The way Mr. Serkian just described it, it sounded like he finished skiing and then was drinking. But I'll just raise the concerns that people have here. We do see injuries by intoxicated skiers at Cabernet, so that is a concern. The biggest concern is that he drove 19 miles. I think that does show an extreme risk to public safety, as well as some judgment issues. For those reasons, I do think a period of probation is appropriate. I do recognize he's done well on bond, so I'm not asking for jail at this time. But I would ask the court to supervise the defendant. Also, this was a Michigan State Police case, so there is a $200 restitution request on behalf of them, as well as a $100 prosecutor fee request. Thank you.
Mr. Carnes, where did the stop occur at?
I believe it was on F55 onto 30 and a half road.
55 and 30 and a half.
I could be wrong about the, no, it's so 30 and a half road in Herring Township at or near South Mackinac Trail.
So the old highway. Okay.
Okay.
All right. And the reason for the stop?
The vehicle crossed the center line. It looks. Let me just read this verbatim. The vehicle had crossed the center line in an improperly used line of travel.
I'm assuming that's supposed to be lane of travel,
I'm
but
guessing, yeah.
okay. And what time of day or night was this?
This was at 2:45 a.m., Your Honor.
And it was 30 and a half road in Mackinac Trail.
Yes, Your Honor.
Mr. Fenton, you have the right to address the court at sentencing. Is there anything you'd like me to know?
No, Your Honor. Mr. Serkian has summed up everything quite well for me. I apologize to the court for my behavior, my misjudgment, and you will never see me here again.
So a question for you. You said you were coming from Caberfay.
Yes.
And you had reservation at the Comfort Inn?
Yes, I just made them on my phone. Yes. I made a wrong turn as well.
Okay, I was gonna say, because how you wound up on 131 where you were, or Old Met
I'm
131?
not from the area.
Yeah,
And I made a wrong turn and I was,
okay.
I think I swerved while I was checking my phone to say, hey, where am I going? And
Well,
so-
probably the .214 wasn't helping either, right?
No, that, I agree.
I know there's sometimes that GPSs will take people way north, but it usually dumps them off on 115 to come down.
Right.
So you would have had to take a wrong turn to get where
Yes.
you were at. So,
Correct.
and so it sounds like the plan was you were going to go home that day. You came up here for a day of skiing.
Right. I'm a season's pass holder at Cabernet. I come up here quite often. I like the Cadillac area and hospitality, and came up with my son and my grandchildren skiing all day, and they were having a birthday party. One of the owners got caught up in the party and way overindulged. And I thought, well, I can't make it back home, so I'll just stay in the lodge. Oh, we're booked solid. Oh, gosh. Okay, oh, they have an opening at Comfort Inn. Okay, I'll try to get over there. And I got off track. I was checking my phone. And anyways, the rest is history.
Had your family gone home, or did they?
Yes, they had left already.
Okay, quite a while before you.
Yes,
assume?
I should. Yeah, I kind of know some of the folks up there, and so I kind of got wrapped up in the festivities, way overindulged.
Your prior offense, the allowing an intoxicated person to operate, do you remember how high your level was then?
0.09.
0.09.
0.09. Okay. And how long had you been asleep in your vehicle before law enforcement encountered you there?
About 2 hours, 2.5, 3 hours.
Okay. All right. Mr. Carnes, is there any indication as to what road conditions or weather was like?
There is not, Your Honor.
One of the things that I struggle with is because I'm used to seeing assessments that will say what level of a substance use disorder you have. No disorder, mild, moderate, or severe. Your assessment just says that you're not an alcoholic.
Correct.
So it doesn't really give me any guidance in that regard. Because where I'm sitting at a 0.214, and you would be able to drive from Cabernet to essentially the north end of Cadillac through the hills. And I don't know if it took you around the lake or if it took you out through Boone and back in, that I don't know. I assume you were using your GPS?
Yes, correct.
Either way, it's quite a feat to be able to drive that at 0.214. So that causes the court some concern, as does your prior offense, which I realize that I understand the situation for it. But if you were asleep in the car for a couple to 3 hours and you were at 0.09, that means you were probably relatively high then as well. And so what I don't know is if it's a binge thing or if you drink, because the other thing that I didn't, I mean, it did indicate that you were a social drinker. And starting when you were legal age, I assume that was 18 back then. So what I'm going to do is, because of the concern I have, more so the fact that you have which I'll give you credit for not driving in the past, but you do have that on your record. It's there. There's nothing I can do about that. But more so the concerning fact is that you were able to drive the 10, 15, 20 miles, whatever it is, from Cabernet to where you were at a 214. And the only thing that brought you to the attention of law enforcement was swerving in your lane. And you said that was because you were checking your phone. That tells me you're more seasoned than a social drinker. So I am going to put you on a period of probation for 24 months. Now, because of the type of offense that this is, you are eligible for early release. So at the 12-month mark, if you've done everything that's been asked and your probation officer has no concerns with releasing you at the 12-month mark, you can be released at the 12-month mark. Or if she has concerns and you think you should be released, you can file a petition with the court, and the court will hold a hearing to see whether or not you should be released. The the law is structured in such a way is you have to meet certain requirements for me not to let you off of that 12-month mark. Does that make sense?
Yes.
All right.
It does, Your Honor.
And as far as when, we don't necessarily have the ability to transfer down to Novi, but we have people all across the state and country that are on probation with us. So our probation department does a very good job of working with people out of the area. So during that time, you are not to violate any law. You are to report as ordered, not leave the state of Michigan without the consent of your probation officer. Keep your contact and employment information current. As I said, you are eligible for early release. You are also to take the alcohol highway safety education class and the victim impact panel. Not to consume any alcohol. I don't believe drugs are an issue, so I'm not going to, I mean, obviously you can't use illegal drugs, but I'm not going to order a prohibition on recreational marijuana. You'll be subject to testing at the requirements of your probation officer. Your assessment doesn't really have any recommendations in it. So I am going to order no bars where the primary source of income is the sale of alcohol, no alcohol or drugs where you reside. I'm not going to order a recovery program because I don't have a basis to do that. I am going to order that any counseling that your probation officer feels as though you would benefit from. And that would include drugs or alcohol testing or counseling. And any other additional programming that they feel you would benefit from. There is a $75 crime victims' rights fee. $250 court, $50 state minimum, $250 fine, $250 court costs. I'm only going to charge half of the probation fee because if you get off at halftime, you're good, which is $360. But if for whatever reason you stay on beyond that 12-month period, you'll be responsible to pay the monthly probation fee.
Yes, I understand.
$100 prosecution fee and $200 to MSP for reimbursement for governmental expenses. Mr. Fenton, you posted your own bond, correct?
Yes, I did.
Ask about the refused PBT because he has a bond posted on that.
Oh, yes. Mr. Carnes, staff advises me that there is a civil infraction for refusal for a PBT. Is that part of this agreement at all, or?
No, it's fine.
Okay. So,
I guess the next question is.
do you, Mr. Securian, does your client still want that set for a formal hearing? The refusal of the PBT? It wasn't, the dismissal isn't part of the plea, so my question is do you want to, we wouldn't do it today, but a formal hearing on the refusal to take the PBT?
I'm sorry, Your Honor, would you repeat that again, please?
Yeah, so your client also has a civil infraction for refusing the PBT.
Oh, okay.
And the question is he going to admit responsibility for that, or are you still requesting a hearing? You'll admit responsibility? All right, so I'm gonna stop imposing fines and costs right now, and we'll jump to that one. That is case number 25517 SI. What is the fine for that?
It incurred a late fee, so, but we waived that, so it's 195. He posted 220, so we
Okay.
can return the rest.
All right.
Excuse me.
Yes.
He says he paid $220 on that.
So there's been a bond posted on that, but that hasn't applied yet because there hasn't been a finding of responsibility on it yet.
Okay.
Does that make sense? Okay. Mr. Fenton, is that true that you wish to admit responsibility for the civil infraction?
Yes, I do, Your Honor.
So I remind you, you're still under oath.
Yes.
So back on February 23rd, as part of this traffic stop, were you requested to take a PBT?
Yes, I was.
And did you refuse to take that PBT?
Yes, I did, Your Honor.
All right. So the court finds you responsible for the refusal of the PBT. That has a $195 fine with that. So we will apply the 220. So we'll apply 220 of that towards that 195. And then we'll apply the balance towards the drunk driving charge.
Okay,
All right. 1 day jail, 1 day credit. So you've served your time on the drunk driving case. Mr. Carnes, is there anything else that I'm missing in the judgment of sentence?
No, Your Honor, thank you.
Mr. Serkin, is there anything else you'd like to see in a judgment of sentence?
No, Your Honor.
All right. Mr. Fenton, any balance that remains unpaid for more than 56 days will incur a 20% penalty. And technically, because I have sentenced you to a term of jail, even though it's time served, you do have the right to appeal that decision. And if you wish to appeal that and cannot afford an attorney to assist with that appeal, you can request an attorney within 14 days to assist with that. I'm assuming then, defense, because we've entered a plea today, your 3 motions are withdrawn?
Yes, Your Honor.
All right. Okay, Mr. Fenton, I'll need you to go back out to the front window where you checked in, get a copy of your judgment, make payment if you're able to, and then I'll need you to go downstairs to the district court probation office and get set up for probation. All right. And again, counsel, my apologies.
Thank you, Your Honor.
Thank you.
Yes, sir.
Thank you, you too.